Assalamualaikum warahmatullahi wabarakatuh. Our topics project is death penalty in Malaysia, whether it infringe human rights. Me, Izzlyn Ainaa Binti Mohammad Zamli, the first member. My metric numbers is 051246, and my friend Ainur Syamimi Binti Rizalman, the second member. A metric number 051236. Our supervisor's name is Dr. Abdul Majid Tahir Mohammad, and we are from Faculty of Law and International Relations of University Sultan Abidin Kuala Nerus. For the introduction, Malaysia is one of the countries in the world that still execute and sentence with death punishment for numerous offences. However, this punishment gets a lot of objection by many human rights organizations such as Amnesty International on allegation that this penalty is a violation against the right to life as enshrined under our constitution. But in 2019, they had decided to retain the death penalty and only excluded the mandatory death penalty. However, on the other hand, there are also certain stakeholders that oppose to the abolishment of death penalty and still support the effectiveness of this punishment as retribution and deterrence. Thus, to analyze the issue of whether death penalty is unconstitutional and deprives the individual right to life, this paper will discuss the legal framework of death penalty in Malaysia, the death penalty in Islamic perspective, and study the views of various parties regarding death penalty in Malaysia. For problem statement, this study on whether death penalty infringe human rights or not is crucial to be done. This is because if it is found that death penalty indeed infringe human rights, it will cause deprivation of many innocents' lives, since Amnesty International reported that the number of persons on death row increases every year in 2016 until 2018. The data is as follows. As we can see, from 2016 until 2018, the number of persons on death row in Malaysia is increasing annually. Amnesty further stated that the scale of the problem is significant. As of February 2019, 1,281 people were reported to be on death row in Malaysia. Therefore, this study will incur a stating that there will be no deprivation of any other innocent's life with death penalty punishment. The objective of this research is to understand the Malaysian legal framework for death penalty. Second, to analyze whether death penalty execution in Malaysia infringe and violates human rights. And third, to ascertain whether death penalty in Malaysia is still necessary or should be abolished.
Alright, the next is the methodology. So the first is the primary source materials like Malaysia Federal Constitution and decided case law. Second is secondary source of materials like the law books, law journals, and articles. Next. The third is the example of secondary materials, which is include online newspaper, reports made by some human rights, the study made by legal research, articles. Okay. Besides, we made some question as regarding our topic in form of Google Form that can be filled by all Malaysians. The questions given are as follows. First, do you know how and what offences can be imposed with death penalty in Malaysia? Second, do you agree if death penalty in Malaysia is abolished completely? Third, do you agree if death penalty is imposed on certain serious crimes only like murder, rape, and terrorism? Last, are you definite and confident with your view and reason?
For our finding, for the first chapter of the Malaysian legal framework for death penalty, we found that in Malaysia, there are two types of death penalty, namely mandatory death penalty, whereby the judges in anyhow must impose death penalty on the guilty accused. And second, discretionary death penalty, where the judges use their discretion to punish with death penalty or any other punishment. There are currently 23 offences punishable by death in Malaysia, out of which 11 are mandatory. So here we can see that section, there are two statutes that provides for mandatory death penalty, which is Penal Code and Firearms Increased Penalties Act 1971. For the second chapter, on whether death penalty execution in Malaysia infringe and violates human rights, we found that from the decided cases, the death penalty is not unconstitutional and not infringe Article 5 of the Federal Constitution as long as it is allowed by the law. In Public Prosecutor Vilau Kihu, the Federal Court held that it is clear from Article 5 Clause 1 of the Federal Constitution that the Constitution itself envisaged the possibility of Parliament providing for the death penalty so that it is not necessarily unconstitutional. And capital punishment is a matter of Parliament, so it is not for the judges to adjudicate upon this wisdom. Similarly, in cases of public prosecutor V.E. Kinsem, where the High Court held that Article 5 + 1 is not infringed because the accused is not going to be deprived of his life or personal liberty except in accordance with law. And the law in this case is the ISA, which is perfectly valid law passed by Parliament. Also, death penalty application in drug trafficking had before been questioned in Court of Appeal in the case of Christine Dermer with public prosecutor, where the Court of Appeal dismissed the appeal and reaffirmed the decision in Lau Ki Hu case that the death penalty under Section 39B is constitutional as long as it is provided by Parliament law. And in current case of Malaysia Bosman, the public prosecutor and other, the court held that the key to construe Article 5 + 1 Federal Constitution for the purposes of the current appeal lies in the proviso safe in accordance with law. The meaning suggested that so long as the legislature has followed the established procedure for the enactment of a statute, then the deprivation of a person's life or personal liberty is valid. Death penalty, according to Islamic perspective also, we found that it is not a violation of human rights since it is allowed in certain offences. For example, offences against the right of Allah, like zina, by which the married adulterer can be sentenced with death punishment. Also against the crime that can be deprived others' life, like intentional murder, and according to principle of siyasah al-syar'iyyah, any serious crime that can affect the public benefit in negative way, like drug offences, which are proven to cause a lot of social problems, like rape and causing injury to other person, also can be imposed with death penalty.
The next finding is whether death penalty in Malaysia is still necessary or should be abolished. So we found that the opponent of death penalty against the death penalty for a few reasons, namely, first, it violates Article 4, Article 5 + 1 of Federal Constitution, which is an absolute right. Second, it does not deter crime. Third, the denial of right to a fair trial to the criminal causes the imperfection in Malaysia criminal justice system. Next, they oppose the execution of mandatory death penalty. Then they oppose the death penalty imposed for the offences like drug trafficking and offences related to firearms. Next. The proponents of death penalty support death penalty because, first, they hold to the concept that there is nothing that it is worthwhile to protect as the cause of human life except human life itself. Second, punishing the criminal with capital punishment or death penalty does not mean that the criminal's rights are violated. Third, death penalty can be a deterrent to serious crime like murder and brutal rape. Fourth, public interest purpose like drug offences in Malaysia. Right? So we come to an analysis that the death penalty is not a violation of human rights considering that it is consistent with Article 5 + 1 of FT, which provided that right to life is not an absolute right and it also allowed in Islam in certain kind of offences. Plus, majority of Malaysians do not agree with the total abolition of death penalty. With regard to the mandatory death penalty, considering that there is imperfection in criminal justice system in Malaysia, due to the denial of right of fair trial, the right to be presumed innocence and the right to adduce further evidence in trial, there might be a high probability that an innocent person can be convicted, and thus it is not safe to impose mandatory death penalty. In respect of the offences that is compatible to be imposed with death sentence, it is the authority of the government to reconsider what kind of offences is suitable to be imposed with death penalty according to the circumstances of Malaysia, in the sense that the imposition can preserve the public security and the public interest. Thus, here, the relevant alternative is the mandatory death penalty must be abolished and the discretionary death penalty must be retained in certain kind of offences which are in the government judgment is suitable to be imposed with death sentence according to the circumstances of Malaysia. Lastly, in conclusion, the death penalty and its nature is not a violation of human rights to life, either in perspective of Malaysian law and Islamic perspective. Render its total abolishment is not proper to be done in Malaysia. At least it is not fair for the majority of Malaysians that are still confident with the deterrence effect of death penalty. The lack or defect that exists here is in the aspect of criminal justice system in Malaysia that needs some improvement, and not the nature of the death penalty itself is lacking. Thus, to improve the justice system, standard of burden of proof is in convicting the accused in offences, imposed the death penalty must reach the standard of yaqeen or without any shadow or doubt of doubt as what the Sharia requires in order to prevent any innocent people to be convicted. Therefore, with an improved criminal justice system, the death penalty can be a vast deterrent of crime in Malaysia. That's all from us. Thank you.